I've been getting high for 48 years.
What? So you're telling me that the second test for cocaine was really the same as the first test because it's just stuck in your system because you've been doing cocaine forever?
What I'm
I don't
saying,
know who the heck you are, but if you start yelling in my courtroom, you're going to be going with her. What'd you say?
Tina Saxon on behalf of Mr. South. Please state your full name for the court.
Kadena Gilso.
Thank you. You're requesting an adjournment?
Yes, Your Honor.
You're waiting. You just got appointed. You're waiting video discovery.
Correct.
Is that on its way?
We have it, Your Honor, so it should be.
Probable cause conference will be adjourned then to February 12th.
Your Honor, I'd like to make a bond modification motion.
February 12th, 2026, 9 a.m. Yes, it's the bond.
Your Honor, Ms. South is being held on $1,000 cash bond. I'm asking for a reduction to a personal bond. It's reported to me that she and the alleged victim do not reside together. He has a different address, so she should be able to return home. And or may not be able to see. She does have a cast on that she will need to go to a physician to address, and being incarcerated, I'm afraid that she won't be able to do that to get it off in a timely manner.
Response.
Your Honor, at this point, I would object. On our bond bill, we requested $25,000 cash period. This involved Ms. Self stabbing the victim in the shoulder with a screwdriver, hit 5 puncture wounds that officers saw. She was also very irate and aggressive at the scene when officers arrived and were berating the victim and then had to be carried to his car. So I expect that this could potentially be other charges in the future for RNO, but at this point, I would object.
Anything else?
Yeah, I would just say that it was a highly intense situation, and berating, calling someone names does not rise to the level of incarceration, I believe, or additional charges. Calling someone names isn't enough.
Well,
but as for
with a screwdriver, that would do it, wouldn't it? You don't need to say anything. Motion for bond reduction denied. Bond will continue. Thank you. She's lucky I won't raise it at this point.
This first ruling turns on risk, not convenience. Defense emphasizes 2 favorable facts. The parties reportedly live apart, and the defendant needs medical attention for her cast. Those points address release planning, but they do not meaningfully answer the prosecution's central allegation that officers observed puncture wounds consistent with a screwdriver attack and encountered aggressive resistance at the scene. At a bond hearing, the judge is not deciding guilt beyond a reasonable doubt. He is evaluating concerns such as public safety, appearance in court, and whether conditions can reasonably manage the risk. Notice the strategic mistake. Defense tries to minimize the confrontation by focusing on name-calling, while Judge Simpson immediately separates speech from the alleged weapon use. That allows the court to frame counsel's response as sidestepping the most serious fact. The judge's warning that she is lucky he did not raise the bond suggests the modification request may have backfired, even though the existing $1,000 cash bond remained unchanged. Do you think the medical and separate address arguments were enough, or did counsel need a concrete safety plan that directly addressed the alleged violence?
These people versus Edna Grima.
Good morning, Honor. Charlotte Steffen on behalf of Ms. Karma.
Good morning, sir.
Good morning.
Your Honor, we're requesting an adjournment for discovery.
The adjournment. Have you seen the progress report?
Yes, I reviewed it with my client this morning, Your Honor.
Why do I have cocaine showing up in her system?
Because, sir, when they test over there, they don't do it the levels. So I've been getting high for 48 years.
What?
Yeah. And so even though it was like, I think the last time was like New Year's Eve or January 5th, one or the other. But you don't show levels, so you don't show it going down, down, down. And therefore, if you got cocaine in your system, you just got cocaine in your system. That's how it is. But that's not okay because it could be in my system for a long, long time, even though I don't get high.
Okay, so just so I'm clear what you're telling me,
Yes.
that on January 5th, you tested positive for cocaine. And that was just,
And I didn't
that was just something in
it
your
should
system.
not have been.
It shouldn't have been there.
Right.
It's just stuck in your
But
system.
you guys don't do
And
it
then-
by levels.
What?
You don't test it by levels to see if it's going further and further.
Okay, so then the next time you're supposed to test, you missed the test.
Huh?
Then you missed the test.
Oh, I didn't have $12.
Oh, okay. And then the next test, almost 2 weeks later, you're testing and you test positive for cocaine. And so, hold on before you, because I want to make sure I've got your story. And so you're telling me that the second test for cocaine was really the same as the first test because it's just stuck in your system because you've been doing cocaine forever.
What I'm
I don't
saying.
know who the heck you are, but if you start yelling in my courtroom, you're going to be going with her.
Okay. This will happen on the 5th, to be honest.
What? What happened on the 5th?
I said that, wait, what happened? Let me think.
I don't know. Go ahead. Think about it.
Right. What I'm saying is on the 5th, I was dirty. I had used like not that far from there, but I was scared to say so because I was scared to say so. So then the next time I didn't have the $12. And the next time
So
it was
hold
still
on. That's what I was getting at before your band started yelling out from there.
my sister. She here
Okay,
from
all right, but
out of town.
so you're telling me this test that showed up positive, you didn't use cocaine.
Which one?
The 20th.
The 20th.
Last
no,
test.
No, I had.
You had
Fifth,
not
the
used
fifth.
any cocaine,
No.
even though you've been using it for years.
Right. Right. It should have been clean. I'm saying I don't understand why it was dirty. But the problem is this, sir. You guys don't check the levels. So you
Oh, I can check levels.
I wish
But
y'all would.
But, well, I can get the levels.
Okay.
That's not a big deal.
Okay.
The problem is because you missed the test,
Uh-huh.
if you did a little bit of cocaine, it'll look like it's going down, but you didn't use cocaine still.
Oh.
You should not be testing positive for cocaine 2 weeks later. That's the bottom line.
This is the credibility turning point. The defendant first suggests cocaine may remain detectable because of decades of use, then admits she used near January 5th, while insisting the January 20th result came from no new use. Judge Simpson fixes each claim to a date because vague explanations are harder to test than a clear timeline. The mistest removes the intermediate data point that might have shown whether drug levels were declining or whether additional use occurred. Her argument about quantitative levels becomes less persuasive once the judge says those levels can be obtained and emphasizes that a positive result 2 weeks later conflicts with her account. Just as damaging is the shift from blaming the testing methodology to admitting she was initially afraid to tell the truth. That admission gives the court a reason to question the rest of her denial. The gallery interruption increases tension without supplying evidence. The judge's warning protects order and keeps the decision focused on the record. Would the defendant have been more credible if she had admitted relapse immediately and proposed treatment, or has the mistest already undermined that strategy?
Grant an adjournment in this matter to February 5th, 2026, 9 a.m. That's 1 week out.
Your Honor,
You're not available that day?
correct.
That's fine. I'll set it on to 12. At this point, the defendant's bond's revoked. She's remanded.
Damn.
What'd you say?
Excuse me. I was saying my sister.
You know, you need to take yourself on out. What? What last one? Oh, was it?
Judge Simpson revokes the defendant's bond and remands her, but the decisive issue is broader than one positive test. The record contains a sequence: a January 5th positive result, a missed follow-up test, another positive result roughly 2 weeks later, and an explanation that changed under questioning. Bond conditions are court orders, and missing a required drug test is serious because it prevents the court from verifying abstinence. The judge was also entitled to assess credibility. He tested the defendant's theory against specific dates, addressed her complaint about the absence of drug-level data, and concluded that the timeline did not support her claim that the later result merely reflected old use. The exchange after remand also shows why courtroom discipline matters. Confusion, laughter, and comments from others do not answer the evidentiary problem. They can instead suggest that the proceeding is not being taken seriously. Still, this was a bond decision, not a final determination of guilt on the underlying charge. The immediate consequence is detention while the matter is adjourned. Counsel can examine the testing records and determine whether reliable toxicology evidence, treatment documentation, or a structured release proposal could support a later request. What matters most to you? The 2 positive tests, the missed test, or the changing explanation? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.